organized as a part of the celebration of Golden Jubilee of the college. When we thought about celebrating the Golden Jubilee, we had planned many programs, notwithstanding various challenges posed by the COVID-19 pandemic, to consolidate and accelerate the march of the college towards academic excellence, among others. The college has become a center of research under the University of Calicut. We have also started the process of publishing hosting invited lectures like this is one of the year-long programs forming part of the proposal. Our objective in organizing this program is to provide our students and scholars to familiarize with intellectuals with the proven skill and a mastery of knowledge and experience in the world, and to interact with them. Inaugural invitation lecture series by Dr. Mohan Gopal, a world-renowned scholar, academic, and thinker, is indeed the most befitting program to start with. Our plan to organize an offline program had to be changed due to, as all can understand, the threat of COVID-19 pandemic. The study of justice has been very old, from the times of Greek thinkers. John Rawls and Amartya Sen are contemporary scholars. Dr. Mohan Gopal is the torchbearer of this critical tradition of legal thinking and justice. That justice is the foundation of Indian Constitution is evident from the commitment of our Constitution to usher in a society in which justice in its various facets is guaranteed to citizens. The importance of the idea of justice and equality was emphasized none other than Dr. B.R. Ambedkar in the Constitutional Assembly itself, especially on his speech of 25th November 1949. In his speech, the father of the Indian Constitution reminded the nation, I quote, on the 26th of January 1950, we are going to enter into a life of contradictions. In politics, we will have equality in equality, and in social and economic life, we will have inequality. In politics, we will be recognizing the principle of one man, one vote, and one vote, one value. In our social and economic life, we shall, by reason of our social and economic structure, continue to deny the principle of one man and one value. How long shall we continue to live this life of contradictions? That question is still resounding. The social and economic life and politics of India, which, as Ambedkar rightly said, was founded on the system of graded inequality. Still, there are disturbing trends emerging in the socio-political and economic spheres of our national life. Clear idea of the notion of justice is prerequisite for a better understanding of the Constitution, which is not a normal legal document. How the executive and the legislature discharge their duty of realization of the socio-economic equality and freedoms for the people, especially to those who are marginalized, also assumes significance in this context. Equality For equally, if not more important, is the role of the judiciary in preventing the static elements in the society so as to promote justice-oriented objectives of the Constitution and, in particular, social, economic, and distributive justice. The sad but exasperating incident of the death of Stan Swami in judicial custody, responses to the disturbing incidents of mob lynching in the name of caste, religion, and cow, and the increasing incidents of denial of equal status of women and sexual assault on women, and so on, need critical examination and discussion. Dr. Mohan Gopal's commitment to the study and analysis of the idea of justice assumes significance as it focuses on the Indian Constitution and its working in the Indian legal system. With these remarks, I most humbly invite Dr. Mohan Gopal to deliver the inaugural speech of the Golden Jubilee of our college. Thank you. Thank you.
Thank you very much, sir, Professor C.V. Kumaran, for the very kind words and the very eloquent presidential address. Professor R.K. Biju, whose presence I wish to acknowledge. Professor Krishna Kumar and Mr. Vidyut, whose presence also I wish to acknowledge, and that of many colleagues from the academy and many students. It's a great honor and a great privilege for me to be able to speak to all of you and really share some questions that I've been struggling with for many years. Perhaps you can help me understand these questions better and guide me towards finding answers. I would like to before I go on, I'd like to confirm that I'm audible. I'm audible, or should I improve my? I can use a mic. Am I audible?
Yes, sir. Yes, sir.
Yes, sir.
Okay, great. So the topic that we have today is the idea of justice of the Constitution of India, and that actually consists of three parts, three questions at least, if not many more, but three basic questions. What is justice? What is the Constitution? And what is the idea of justice of the Constitution? And I would like to begin by saying that my approach to these questions, which I've been struggling with especially for the last 17 years that I've been involved with judicial education in this country, very intensively, and I'm still continue to be involved in that, is basically, I have two objectives in my discussions. One is I want to democratize the idea of justice. I want to democratize the idea of justice, and I'll explain that in greater detail. Second, I want to contextualize the idea of justice. Because normally when we lawyers or people in the legal profession are asked what is the idea of justice of the Constitution of India, our first trained instinct is to look to judgments of the Supreme Court or of high courts and then look for definitions of the constitutional idea of justice there, and learn from that. And I think this is what, in my last intervention, which I had under the auspices of Professor Kumaran a couple of days ago, we discussed these different approaches to thinking about law. And one approach to thinking about law is to simply look for rules or precedents or statutes, discover them, and then apply them. And I think that's a very important craft and a very important set of ideas, of knowledge, and we should do that. There's nothing wrong with that. But there is another approach, and that approach is to understand that the Constitution is part of a larger life of a people. The Constitution does not come from thin air. It comes from the people. It exists, it lives in the people, it dies in the people. And therefore, to say, look, yes, the Supreme Court has a view about what the Constitution is, or what justice is, or what the constitutional idea of justice is. But the Supreme Court's view is only one view. And we need to have a more robust, more grounded, more authentic understanding, scientific understanding of this question independently, each of us, especially as academics, so that we can measure the rightness or wrongness of the Supreme Court's view against our own idea of the Constitution and of justice and of the constitutional idea of justice. Our job as thinkers about law, students of law, not as litigants, not as in our capacity as, say, officials or government servants, but as thinkers about law, our job is actually to evaluate and judge and assess the views of courts and challenge them where necessary, so that one day some future court may realize that an ADM Jabalpur was wrongly decided and overrule it. If that has happened today, the credit goes not to the judiciary, but to many thinkers about law, many academicians who relentlessly questioned ADM Jabalpur and created an environment where the judiciary finally realized that it was wrong. So for the health of our democracy, the health of our society, it is very important that we academics, as individuals, must have our own very clear idea about these three questions. What is a constitution? What is justice? And what is the constitutional vision of or the idea of justice of the Constitution of India? Because against this, we will be able to evaluate and guide all of us together as a community. We may differ with each other, it doesn't matter, but through our discourse, we will make sure that the judicial system moves forward, because frankly, there is no other community that can challenge the judiciary except legal academics, no one else, with any knowledge or with any credibility. And if judicial review is the cornerstone of the Constitution, then the legal academy is the cornerstone of the judiciary. And if the legal academy is to be the cornerstone of the judiciary, then we must have our own highly mindful, thought-through, substantive idea on legal questions, against which, as I said, we must judge the work of the judiciary. So my discussions with the judiciary and in judicial education and today are actually prompted not to give you an answer to these questions, but to share some thoughts I have about these three questions, so that hopefully we as students of law or teachers of law can start to take this question much more seriously and start to develop over the next few years our own, each of us, our own understanding of the way these three very fundamental questions are to be answered. let me start with an actually the less obvious question. What is the Constitution? What is the Constitution? So if you look at the dictionary, the English dictionary, the English dictionary says a constitution is basically says it's a body of fundamental principles or fundamental rules on the basis of which a nation or an organization is organized. And so in a sense, it is a set of principles that constitute something. That's why it is called a constitution. Constitution is almost like an action. It is a process of constitution. And therefore, it is very fundamental because India is not just a piece of territory. At its essence, India is a set of shared principles and values which are codified in the Constitution. And therefore, we can say that the Constitution is a set of shared values, shared principles that are fundamental to the republic that it proclaims. It constitutes. Now, this Indian Constitution, so that is a very formalistic definition or understanding of what is a constitution. It is a set of principles, yes. It has constituted something. We know that it itself says in its preamble that it has constituted a republic with certain qualities and characteristics to which we will come. And then we look, it has various, it creates organizations, it creates powers. But going beyond that, the Constitution, whether it's a small club or a small society or a small group of people or an entire nation, as we know from our own experience, that Constitution becomes actually a part of the larger processes, struggles that group experiences or is engaged in. So you can see that there will be in a small club, somebody will use the Constitution to challenge the president or to change the president. They will use it for their own purposes. And therefore, the second step is to understand, yes, there is a statement of principles, but this statement of principles may not be necessarily acceptable to everyone over whom it has jurisdiction, whether it is a nation or a club. It may not be acceptable to everyone who has who it binds, and all those people may not have the same interests. And so at the second step, we say, okay, it is a set of principles, but then suddenly we realize that the Constitution is a site of struggle. It's a site of struggle. Especially when it comes to the Constitution of a nation, it is a site for struggle, of struggle, between various groups of people, various interests that were fighting without a constitution or outside the Constitution, but now suddenly there is a new site. It is not the only site where that fight takes place. And that's why I said a constitution appears in India, constituting a new republic, but does not come out of thin air, and actually simply comes into a river of struggle that is actually already flowing. And it is only when we view that constitution from the point of view of this river of struggle into which it has been put, that we start to understand its significance, its real significance. Otherwise, these words, we cannot understand the real meaning or significance of the words or the institutions or the organizations or the interactions that it creates. So the second step is for us to understand the river of struggle into which in 1950 this constitution, from which this constitution emerged. And that is a very large topic, but one thing we know for sure, that when the constitution was drafted between November 1946 and November 1949, when the drafting was more or less completed, adopted in January 1950. The first meeting of the Constituent Assembly was in December, actually, 1946. The Constituent Assembly Objectives Resolution was adopted on 13th of December 1946. So 47, 48, 49 were the three substantive years in which the Constituent Assembly met to draft this constitution. And when that happened, India was in the middle of a civil war, a massive civil war. Indians or people of this subcontinent were killing each other in a way that, to our knowledge, no invader has done, no conqueror has done. Indians were brutally slaughtering each other. That's not in our nature. We are Indians. We are not brutal, violent people who slaughter each other. Something drove us to that. Some set of forces drove us to that. So the Constituent Assembly members, very varied, vast majority of them being older, male, upper caste, rich, privileged, powerful people, a small number of them being in other categories, including women, a very small number of them being Dalits, Bahujan, to use today's terminology. But all of these people were coming to the meetings of the Constituent Assembly in the middle of this huge civil war that was raging around them. They were seeing trains with dead bodies coming in to Delhi and being sent out of Delhi. They were seeing brutality and violence which very few people would ever see or even imagine. Therefore, it is based on that. My first substantive sort of submission is to understand that if there was any unanimity and any agreement in the Constituent Assembly, in that environment and atmosphere, it could only have been one thing, that this kind of civil war should never happen again. It should never happen again. That is their main objective. And therefore, and one advantage of these people was that they had emerged from a freedom movement. They had emerged from a long struggle with the people of this country. So the people of this country were not alien to them. Many of them, like Dr. Ambedkar, were from the people. They were the people. The others were ruling classes, but still had interacted closely with the people. So they understood why the civil war had happened, and they had a theory on how to prevent it. And that theory is what we find in the preamble. The theory is, we know that unity of the people, fraternity of the people, both of which are mentioned in the preamble, sometimes is sought to be imposed from top down, prescribing a set of mandatory behaviors, conducts, values, teaching, training, giving propaganda, convincing people to adopt those values which are imposed on them, and then maintaining peace and harmony when people obey those values. But we know from our experience that it was because of the failure of these top-down attempts that India had a civil war. The British tried that. Before that, the Mughals tried that. Various people tried that. The Guptas, the Mauryas, going backwards. None of that succeeded. So they realized that the only way to maintain unity and harmony and fraternity in our country is bottom-up, based on individual liberty, based on equality, based on a commitment to individual dignity, and based on liberty, equality, and dignity, a fraternity of equals. And they realize that it is this framework that that will maintain peace in this country, and there is no other framework. So therefore, the Constitution has two parts, in my view, to it. One is a part that provides a framework for people to talk to each other, to be heard, to be included. They realized that the Civil War took place because people had been excluded from legislation, from the executive authority, and from the judiciary, and from civil society, and from public spaces. And so the focus of the Constitution was inclusion, was to ensure that everyone had representation, everyone had voice, and everyone was included. So one part of the Constitution actually provides a very, very strong legal framework to ensure that everyone will have space in a public conversation to decide what will happen to this country. And there is no need to kill each other. We can do better than that. We can talk to each other. And so freedom, equality, dignity, and fraternity becomes really the core framework of a public conversation or public discourse in this country, from which no one can be excluded. The second part of the strategy for keeping India at peace is to give equal, universal adult franchise, one person, one vote, for all the people of this country. And that way, whether you are rich or poor, educated or uneducated, as Professor C.V. Kumaran said, quoting Dr. Ambedkar, we will have one political value. Very, very important for Dr. Ambedkar that we will have one political value. But having one social and one economic value is the challenge that he placed before us, in which we have to engage in order for this conversation to actually meaningfully take place. The third instrument, which was introduced by Dr. Ambedkar into the Constitution for integrating all groups in society, bringing them together, giving them equal voice, equal representation, and making sure that the affairs of the Indian state are the result of the joint decision-making and shared power of the people of India, was reservations. The purpose of reservation was not simply to make backward people forward, backwardness being just a symptom, or for economic advancement, poverty being a symptom, but they realized that the root problem was, the root source of violence and of backwardness and of poverty was exclusion of voice. And therefore bringing everyone together to ensure that in 4 critical domains, the legislature, the executive, the judiciary, and in education, everyone must have their due share and equal voice, because that will ensure that this country will never have civil war again. So we understand the Constitution as part of an ongoing struggle of the people of this country. That struggle was a very complex struggle, and I will very briefly touch on what that nature of that struggle is. But the first priority was, when that struggle ended in mass murder, the Constitution makers said our first objective is to ensure that people of India live in peace with each other, and for that they constructed a set of principles for a conversation. And I believe that this is the basic structure of of the Constitution, is basically the basic structure of a free, equal conversation between people, where everyone has voice and representation. That is the core of the basic structure. Then we come to the second part, the second challenge of the Constitution. This vast republic, this vast sea of humanity, the largest group of poor people in the world, what kind of substantive policy choices must it make as it moves forward? So on one hand, they had a group of people who said the substantive choice we must make is a Hindu Rashtra to keep alive Chaturvarnya and the old social order, repair it, fix it, but keep it going. And on the other hand, at the other end of the ideological spectrum, there were people who had a very clear idea that production relationships must be reorganized, private property must be abolished, the proletariat must rule, and that is the substantive way for India to go forward. Now, the Constitution remained neutral, largely neutral to these different points of view on how India should go forward, and provided a framework of a democratic conversation through which these choices can be made by the people. And that's why Dr. Ambedkar said that the Constitution, the power of future parliaments to amend this Constitution should not be restricted. Now, therefore, if we understand this Constitution as a site of struggle, which at the minimum, at the core, provides a framework for democratic discourse and conversation, and instruments and institutions for dispute settlement and making ideological choices. And then we also recognize that there are forces, ideological forces that have strong vested interests on imposing their ideologies on this country that they believe are good for this country. Then we understand that we have to ourselves decide, now that we are 70 years beyond the introduction of the Constitution, we must ourselves as lawyers have a position on what is the kind of future that we want for our country in terms of substantive policy choices. And where and how should we take this forward? And at the broadest level, there are two choices. One is a vision that takes us backwards to a society that existed in the past and tries to revive an old society. And another view is to take us towards some unknown future, some known or unknown future. There is also some ideologies which demand obedience to those ideologies, and other ideologies which demand that we must do independent thinking of our own, which is what the Constitution gives us the opportunity to do. We can use that to do independent, to be obedient as well, if that's our choice. So what we need to do, I think, is to understand that there is a struggle. And the revolution of the Constitution, the primary revolution of the Constitution and its basic structure, is simply creating, for the first time in the history of the subcontinent, a democratic discourse based on equality and freedom, where everyone can participate on equal terms. If that happens, and we are far away from that, if that happens, and everyone's voice is equally respected, is equally heard, and power is distributed based, as was clearly discussed in the Constituent Assembly, based on the due share according to population of the large group of communities and interests and classes that constitute our country. That itself is a huge revolution, a huge revolution. Now, where that will take the subcontinent, we don't know. But the Constitution says, look, where this subcontinent goes must be decided by the people, not by a group of vested interests forcing their view on the people by enslaving them again and making them obey whatever ideologies is sought to be thrust on them. So when we look at the Constitution, the constitutional revolution that we are looking for is really to create a democratic discourse and then through that democratic discourse based on equality, liberty, dignity, and fraternity to go forward. Now, I want to share with you a recent judgment of the Supreme Court, which actually shares this view for the first time, gives a new understanding of the Constitution. This is the name of the judgment, Prithviraj Chauhan versus Union of India, Ravindra Bhatt. So here the Supreme Court itself is not asking the question, what has the Supreme Court said is the Constitution, right? In fact, it kind of distances itself from that. Look at paragraph 14. The Constitution of India is described variously as a charter of governance of the Republic, as a delineation of the powers of the state in its various manifestations vis-a-vis inalienable liberties, and a document delimiting the rights and responsibilities of the Union and its constituent states. Now is the important part. The Supreme Court says, Justice Ravindra Bhatt says, it is more. It is also a pact between people about the relationships that they guarantee to each other. Apart from the guarantee of liberties vis-a-vis the state, in what was once a society riven along caste and sectarian divisions. That is why the preambular assurance that the Republic would be one which guarantees to its people liberties, dignity, equality of status and opportunity and fraternity. So the Supreme Court is saying that the Constitution is a pact between people about the relationships that they guarantee to each other. It's a very, very interesting, very innovative definition of the Constitution. It is an agreement between people, not between the state and the people, on the relationships that they guarantee each other. So this is how the Supreme Court has also looked at the Constitution, not looked to its own dicta, but to understand that there is something going on amongst the people. And there is a struggle between the people on how they should treat each other. And the Constitution provides a benchmark on how people should treat each other. Now, against this background, I want to ask the question, what is justice? So what I've said so far is that the Constitution is a site of struggle. It's a site of struggle. And the main point on which all of us are struggling, is to first of all create a society where everyone has a seat at the table and everyone can participate in that struggle. Not just a few elite leaders, but every person can participate in that struggle. That is the first step of the revolution that the Constitution has put before us. After that, after we achieve that, or in parallel with that, or along with that, we also take forward substantive visions about what kind of society we should be. Now, clearly, here there is a problem. The problem is, for some people, their substantive vision of what society should be does not want everyone at the table, does not want equality, does not want liberty, does not want dignity. They do not want fraternity. They want to impose their ideology top down. And so even this first revolutionary goal, which the Constitution clearly has created, is controversial. I sometimes feel there are people, ideological groups in this country that want freedom but not equality. There are some ideological groups that want equality but not freedom. There's a third set of ideological groups that want neither freedom nor equality. But there is only one really committed group of people who want both freedom and equality and democracy. They want it all, and that's the scheduled caste, scheduled tribe population of this country. They want democracy, they want equality, they want freedom, and they want it for all. They're not satisfied with one or the other. And Dr. Ambedkar was their voice, very powerful voice. But this is their strength. So even in this first struggle, there are 4 different points of view of whether this is a good objective or not, but the Constitution is committed to that. If it is not committed to the second generation question of what kind of society we should be, what should be the role of private property, what should be the role of religion, these are separate issues which we will also, of course, now that struggle is also ongoing, we will face it. But the Constitution wants us to focus on creating a democratic space, public space in this country. Now, against this background, first we ask the question, has the Supreme Court actually adequately recognized that this is what the Constitution is, that it's a site of revolutionary struggle and not simply a legal document that sets out rules? And I would say, with the exception of a few judgments like the one I pointed out to you, Prithviraj Chauhan, by and large the Supreme Court and the High Courts have failed to understand that. They have seen, as this judgment says, the Constitution simply as a set of rules, not as a site of struggle and an attempt to bring people together so that to avoid civil war in this country by giving everyone equal voice and a due share. Okay. Now, against this background, we come to the second question, which is, what is justice? What is justice? Now, here I would like to point out that again, this is a very long discussion, but I'll just very briefly summarize. There is a lot of diversity and variety in approaching and answering this question, and at least at 2 levels. One is from a discipline point of view. This question, what is justice, has been looked at by philosophers, by social scientists, by economists, by scientists, and by lawyers like us. So each discipline has its own approach to justice, and some are cross-disciplinary. The second pole around which the question is approached is ideological. And so we have maybe at least 15 leading theories of justice in the world, and all of which are well known, taught by law schools throughout the world. I've been learning this as a student and later on after becoming an academic. But frankly, there is no consensus around any of these answers. So after all these years or centuries, we still don't have a universally accepted idea or definition of what is justice. And the field is so confused that most students who study jurisprudence on what is the theory of justice, like I was there myself, we get very confused, because there are all kinds of subtle distinctions and all kinds of complex, esoteric nuances, which doesn't make sense to them at all. So therefore, our starting point must be a somewhat startling position that actually the word justice is an empty word. It has no real meaning. It is like the word dharma, dharayati iti dharma, that which upholds. But upholds what? And what upholds what? Why? So it's simply a process. It is simply a heuristic. It is simply a shortcut to describe something else. So our starting point must be to honestly recognize that if after all these years, there is no consensus on what justice means, unlike many other important words, then let us be honest and admit that inherently that word is empty, it has no meaning. Let us be honest about it. That then gives us the responsibility to provide it meaning for our purposes. and take accept responsibility for that. Why? Because the Constitution of India gives prime place to justice. Justice is the first objective in the preamble of the Republic. Article 39A says that the operation of the legal system shall ensure, the state shall ensure that the operation of the legal system promotes justice on the basis of equal opportunity. Article 38(1) says that the state shall promote the welfare of the people by securing as effectively as it may a social order in which justice, social, economic, and political shall inform all institutions of national life. Justice is dripping from the Constitution. It's a very important word in the Constitution. So we have to accept that it has no meaning as a word. It's like happiness and many other similar words that suggest something. It's a pointer word rather than a substantive word. But we have to give it meaning. So how do we do that? So in a very brief way, I would suggest the following. One is, let's understand the etymology of the word. The etymology of the word. It comes from two words, J-U-S, use. Use means right value, right value. The right value of anything. I want just half a cup of coffee means the amount of coffee that's good for me is half a cup. So just, that's why I use the word just. That's the quantity that fulfills the use, the norm, the right norm of what is correct. But in the context that we use it in law, that's where it becomes important for us to understand we are trying to give meaning to the word justice in the law. So in the law, we have to give justice taking into account one unique characteristic of the legal system, one unique characteristic of the legal system. Perhaps the most important characteristic of the legal domain is that the law deals with only one question, only one question. All of law deals with only one very simple question. Is human conduct right or wrong? And if it is wrong, what are the consequences? There is no other question that law deals with. If this question is not relevant, it's not a legal question. Now, this is not a question only for law. It's also a question of ethics and philosophy. But law approaches this question from the point of view of the interest of the state, of a ruling body that wants to establish norms and enforce those norms and secure compliance with those norms. So from a governance, so these are ethicists who are interested in governance. Therefore, we know that if we have to look at justice from a legal point of view, we have to see just use, J-U-S, as a rights, the standard of right human conduct. The standard of right human conduct, use. Because that's our concern, rightness or wrongness of human conduct. So we understand use is a standard of right human conduct. The word stis is the other limb of justice. And there is some source I have to show how I get that, but I'm not, lack of time, I'm not going there. Stis means that which stands, like solstice, the sun stands. We say that summer solstice and winter solstice, the sun moves, it stands still, and then it moves in the other direction. The day it stands still is called solstice. Sol means sun, stis means stand. So use plus stis means a right value that stands, a right value of human conduct that stands. That's not temporary. That is long lasting. So justice refers to a set of eternal values of human conduct. So when the Constitution says to secure to ourselves justice, social, economic, and political, what the Constitution means is that we want to create a country where human relations, social, economic, and political, are governed by eternal values, a set of eternal values that don't change from time to time. What is right today may not be right the next day. There are ephemeral right values, and then there are eternal right values. At least people proclaim that to be eternal. So when members of the Sikh religion say Sat Shri Akal, they are proclaiming to each other their core value, that there is no God but truth, and truth is eternal. So these eternal values of what is right conduct or what is wrong conduct are actually what constitutes a nation. So now we understand that what a constitution does as a site of struggle, when it enters an ongoing struggle, a struggle of people in the subcontinent who are conflicting with each other over various matters and various issues, a vast and diverse and conflictual landscape. When this constitution comes in, what it is offering is a set of eternal values around which we can build unity. And on a stable basis. So we are now understand that the idea of justice, I would suggest, is actually a standard of human conduct, which is considered to be eternal, not to be changed. Because if it is changed, then if in India changes. If life, liberty, and the pursuit of happiness is no longer the standard, the set of values that the United States pursues, then it's no longer the United States. If justice, liberty, equality, liberty, equality, dignity, and fraternity are not the values pursued in this country, then it's no longer the Republic of India. It's something else. So we now understand that justice is a set of right, is a standard of human conduct. And different people have different approaches to what are eternal standards of human conduct. As I just said, the Sikhs may have their own approach. But the constitutional idea of justice must be the standard of human conduct that is established in the Constitution. That is the constitutional idea of justice. The constitutional idea of what should be the norms of conduct that should guide people in this republic. And that is why the Supreme Court in Justice Ravindra Bhatt's judgment says that the Constitution is actually an agreement on norms of conduct. And so it is a document or a body or a codification of what we are committing to as standards of conduct and how we treat each other. So freedom is about how humans treat each other. If my freedom is limited by a tree falling in front of me, I won't say I have that, I can't go to court and complain that, I have no cause of action, unless there was a human element in it, that someone failed to cut the tree in time or failed to take preventive action in time. But without a human action, I cannot, it doesn't enter the legal domain or the legal system. So when we talk about values of human conduct, when we talk of freedom, we're talking about how we treat each other, that we as human beings shall not take away the freedom of each other. When we talk of equality, we are committing to giving equal value in our treatment, in all our actions, equal value to people regardless of their birth, their gender, their caste, their religion, their race, that we give equal value to people, of their money, their wealth, their power. Dignity is also about how we treat each other. Fraternity is about how we treat each other. So now these two ideas come together. When we understand the constitutional project as responding to a tremendous history of conflict and division in this country, and the solution that they have come forward with is to establish a set of human values of human conduct on the basis of which we can create a society that will no longer have to conflict with each other, and will be able to deal with their differences in a peaceful manner without the kind of civil war that we had in 1947. So the second point I'm saying is that justice is a standard of human conduct. that the constitutional idea of justice is the Constitution's approach to what is the right way for us to treat each other, which the Supreme Court has also now recently endorsed. All these years I had to say it as my own proposition. Now I can point to a Supreme Court judgment that says the same thing. And now we come to the content of this. The content of this is found basically the four core values are in the preamble: freedom, as I said, freedom, equality, dignity, and fraternity. And once we get into into part 3 and part 4, we see these ideas fleshed out. Part 3 fleshes it out in terms of various categories of freedom. Part 3 also gives, that is in Article 19, Article 25 gives us freedom of religion. So there is freedom, liberty interspersed in Article 3, in the various parts of Article 3. There is equality interspersed, not only in 15, 16, 17, and 18, but various other aspects of part 3 is you'll find equality, similarly dignity and fraternity. If you go to part 4, you will find programs directed at the state, obligatory on the state to realize these values. Very inspiring programs, that there must be equality should mean not only minimizing inequalities of wealth between individuals, but also between groups, for example. It talks about the condition of workers, the condition of children, the condition of the environment. So it gives us various fleshed out details of these 4 core principles on how we should behave. Now, the idea and the theory is that if we maintain and respect these values of conduct, we will be able to avoid civil war and be at peace with each other. Now, so I've described to you the Constitution as a site of struggle, an intervention in a continuing river of struggle of the people, an intervention. And the nature of that intervention for India is providing a set of values that should govern how we treat each other. And that is basically what is justice. And these values are stipulated in the Constitution, because that is the core contribution of the Constitution to this country, that if we treat each other in this manner, we will be able to live in peace with each other, and then decide where we will take this country. And as Dr. Ambedkar said on more than one occasion, it was not his intention to bind future generations. The last part I want to come to is what is the struggle, what are the challenges faced by this approach, this framework that the Constitution represents. The Constitution is simply an argument to the people of this landscape that maybe this is a way you can live in peace. It's just an argument. And it has mobilized money and resources and state power behind that argument. If that argument is not accepted by people, and people say, no, we do not want equality, liberty, and fraternity, or sorry, we want it, but we'll get it through another way, not through the institutions of legislature, executive, judiciary that you created, but through other ways, then they will ignore the Constitution and they will pursue these other ways, violent or non-violent, and they will go their own way. So what we have to do is to find a way to understand these challenges coming from society, not from the judiciary, not from the legal system, not from the bar or the bench, but coming from society. What are the boulders, the rocks that are standing in this river, in the flow of this river, that will impede this flow of life of the people of this country when we go forward? So we find that when we look at that, we find a number of challenges, and those challenges are are basically coming from, in my view, in one form or the other, from three forces, which want to subjugate the people of this country. Three forces that want to subjugate the people of this country. And very broadly speaking, for lack of time, I'm coming up to 4:15 when I'm supposed to stop. Roughly, I may take another 5 minutes or so. These three forces are, in order of importance, in my view, in order of their power and their entrenchment. The first is religion. Now, religion, I mean organized religion. I don't mean spirituality. I mean organized religion. Organized religion exploits the human need for spirituality. The human need to to think about or reflect on questions to which we do not have answers, and we may never have answers. We may be incapable of knowing the answers to. That is spirituality. I think Bertrand Russell, it was, who once said that what we know we call science. What we don't know but we think we can figure out, we call philosophy. And what we don't know whether we can ever know, and we really haven't even begun to think about seriously, we call spirituality. Right. So you know that one science was called philosophy. These disciplines emerged only later. So once we know something for sure, what is the cause of the common cold, then we put it as science. Right? And otherwise we put it in philosophy when we're still thinking about it. And then if we can never think about it, we put in spirituality. But these three domains are there. So this domain of spirituality is used as an instrument of political power. That's not a new insight. It's very well accepted and well recognized. And here the challenge is for us to change our mode of thinking from obedience to questioning, from superstition to reasoning. And the problem is that I find that for this, legal academy has to be very vigilant and strong, because we have these religious forces operating inside the legal system. The law is supposed to be an instrument to bring about this transition from independent questioning, from obedience to independent questioning, from faith to reason, from superstition to evidence, fact-based thinking. This is at the heart of the Evidence Act. I'm a great admirer of the Evidence Act. And if you look at the definition of fact, it's an amazing definition. It is a fact is a thing or a state of things or a relation of things capable of being perceived by the senses, or a state of mind of which somebody can be conscious. So unless through my sensory inputs I understand, I can see some, it's a very materialistic view that unless through sensory inputs I experience something, it's not a fact in law. It's a very scientific understanding of law. So, but it is not these kind of, what is reasoning, what is logic, what is rationality. These are issues that need to be a central part of our legal education if we are to move from a culture of faith and obedience to a culture of questioning. Which is what this framework of public discourse that the Constitution wants us to have, of freedom, equality, dignity, and fraternity, that is premised on rule of law and reasoning and rationality. This discourse has to be fact-based. It has to be based on logic and reasoning. It cannot be based on superstition. It cannot be based on lies. That is what is meant by secular in the preamble. And therefore, unless we bring about that change and we push back the dominance of superstition I always say that caste is only a superstition. It is nothing more than a superstition, a set of false beliefs that individual capacity somehow related to a group in which you have membership by birth. I mean, there cannot be a more, sorry to use a strong word, stupid idea than that the capacity of an individual is based upon the social identity of the parents to whom you are born. So we have to fight against, so one big obstacle we have is religion. When I say religion, I mean organized religion, not spirituality. And I particularly am referring to the fight against superstition, the fight against faith, blind faith, and the need for questioning and the need for rationality and reasoning. I was looking for a very nice quotation which I wanted to read out to you, but as usual, when I need it, I don't find. Yeah, I found it. This is a quotation from Ernst Renan in 1882. He says, at that time, in 1882, he's talking about Europe. He says, we have driven metaphysical and theological abstractions out of politics. We have driven metaphysical and theological abstractions out of politics. What then remains? Man, with his desires and his needs. So unless we use the law to drive out metaphysical and theological abstractions from public policy, from thinking about the constitution, thinking about law. Like the other day, I was really sad to see a Kerala High Court judgment in which there is a reference to God being with us and protecting us. So this is really going against a basic project of the constitution of converting us into a society where we can have a equal, free dialogue based on fraternity and dignity and based on truth and facts and reason and logic. And so that is the first big force that is fighting us and opposing us. And I think I find with great and due respect and great admiration for my state and my community of lawyers here, I find that this is a challenge that we have to, there is a strong conservative culture in the Kerala Academy, in the Kerala Bar and in the Kerala Judiciary. Strong conservative influence. And I think somehow we have to consciously change that and bring in a much more progressive culture where we demand fact-based thinking, questioning, and going and not simply obedience-based application of rules to facts and without questioning the fundamentals. So that's the first thing. The second very big force that is fighting us is basically the economic forces, the market forces that they look at us as people who, when the British were ruling us, are, they look at us the way some of our dominant social groups look at the masses of people, that we are biologically inferior people and we are we are not fully humans, and they want to extract our labor, extract our resources, and exploit us. And again, the only way we can fight these forces is by building democracy, by giving everyone voice and everyone inclusion, and ensuring that everyone has adequate representation, no one is included, and that includes also women. We must fight the prejudice of gender, we must fight the prejudice of caste, we must fight the prejudice of communalism. We have to ensure that oligarchies are broken down. Oligarchies are broken down in the society. The best way to defend ourselves is through building our democracy against these social forces. Religion does not want democracy. Religion wants a small group of priests to rule us. All religions, a small group of people who are directly connected to God will rule us, not ourselves. The word democracy comes from two words. Demos means people, kratos means power. Democracy means power is in the hands of the people. And the third force that is a very, very powerful force, which is is changing the way all of humanity lives, is technology. And many of you may have seen a small excerpt of a video by Elon Musk, the Tesla entrepreneur, who is asking for regulation to democratize and have democratic control over artificial intelligence, because he says it is a grave danger to humanity. A small group of people are gaining control of artificial intelligence and massive amounts of data, and very soon he feels it will be too late. We will not be able to have democracy anymore. Now, again, the response for us must be to be very clear about our response to all of this is democracy, based on equality and freedom, and dignity and fraternity. So building a strong democracy using the constitutional idea of justice must be our response to these three forces that are pushing back against our ability to realize this constitutional idea of justice. So let me conclude by simply saying that the constitutional idea of justice is that we have a society where we treat each other as equals. We respect each other's freedom to the maximum, individual freedom to the maximum. We value everyone's dignity. And based on these three principles, we build bottom-up a society based on fraternity, based on principles of secularism and socialism. Socius means friend, where we care for each other and we are compassionate to each other and we share power and we make sure that everyone has a voice in deciding where we go. That is the constitutional idea of justice. And justice, if justice is a standard of human conduct, we say justice prevails when human conduct matches the concept of justice. That the crystallization of these standards of human conduct into actual human conduct is what we mean by securing justice. Justice only occurs when human conduct is in line with these values that are proclaimed in the Constitution. Justice is not a decision by a court. A court by its decision does not give justice unless it manages to ensure that actual human conduct is aligned with these values that are stipulated in the Constitution. So this is a quick summary of a very vast and complex subject. And my main message is, my request is that each of us must reflect on these ideas independently. We must develop them in our classes. We must encourage our students to in their day-to-day, in our classrooms, to practice these values. We should stop using words like your lordship and my lordship to judges. We must have a democratic classroom, democratic language, democratic culture, so that at least when these students become judges and lawyers, we will be able to put the feudal and colonial past behind us. But the beginning has to be made in the classroom, And we must make sure that in our classroom, we produce people with a conscience who will defend these values throughout their life. When Professor Kumaran referred to Stan Swami, when he died, I shared a message with some fellow academics. And I said that, look, I feel ashamed. I hang my head in shame that because no student who has been in our class should be able, as a lawyer or as a judge, to do what these lawyers and judges who were students of some teachers, all these lawyers and judges were in some classroom, they were teachers of some students, did by sending whatever wrong thing he may have done or may not have done, by sending an 83-year-old man to certain deaths in a prison that are no doctors and a lot of COVID. So there should be lines that our students will never cross. They should never be able to cross the line of treating someone as less and violating the principle of equality. They should never cross the line of taking away anyone's freedom except to protect freedom for no other reason. They should never be able to allow anyone to violate anyone's dignity. They should always stand up for fraternity. If we can put these values, integrate them into the cultures of our classrooms, then I think we would have realized the constitutional vision of justice in our own classrooms, which is something that we should try to do. Thank you very much. Thank you.
Thank you, Doctor. Thank you, Doctor. And now it's time for the participants can ask questions. What type the queries on the chat box?
Hello, sir. Good evening. Good evening, sir. I am Safi Mohan from Government of Police Trivandrum. So, thank you very much, sir, for your enlightening words. And so I found one of the most important fact that the Constitution. I found this view, sir, that this Constitution is actually a philosophical document, and it is a compassionate document, as you mentioned. And this document is tied to struggle. So I think spreading the constitutional idea and teaching this constitutional idea is our duty, and I think it is also our right. But unfortunately,
Safi, your voice is not coming through.
sir, actually, those who are defending the constitutions are sometimes the state saying that they are sometimes against the constitution. So, what is the way in which we can defend the constitution when we really understanding the fact that constitution is failing? I think that is actually happening in the case of even the father Stanford's case, because I think Father Stanford was actually defending the constitution by providing justice to the ordinary people of this country. So my question is, how do we get justice from this democratic institution in the judiciary?
See, Safi, very, very good question, and I think we see the Constitution as a compassionate document, but the most important thing is for us to understand deeply, and we have to. I feel that in our legal education we must have entire 3 courses, one separate course on liberty, equality, and dignity and fraternity. I mean dignity/fraternity. We have to spend, every law student must spend 1 semester understanding freedom, understanding liberty. The reason is, and I said this to a very senior group of judges just 3 or 4 days ago in connection with judicial education. And I'll come back to your question, Safi, in a minute, but I do want to make this point. What I said is that on January 26, 1950, the Indian judiciary was an experienced judiciary when it came to, with a long jurisprudence, common law tradition, when it came to enforcing private property rights, enforcing religious rights, social issues, civil disputes, civil procedure, protecting the state, law and order, crime, criminal law, police. It had lot of experience. But there is one area in which the Indian judiciary had absolutely no experience on 26 January 1950. No experience. And that was how to protect civil and political rights that are entrenched in a constitution. How to protect fundamental rights, liberty, equality, dignity, freedom. The Indian judiciary is inexperienced in this. And democracy, which is the combination of liberty, equality, fraternity, and dignity. Democracy is the outcome of that. When all these prevail, then there is democracy, not otherwise. It's not separate from that. But the Indian judiciary does not know how to do this, because 1935 Act did not have any rights. And no system of law in this country, in the long history of this subcontinent, has had such a history. So this is why actually, in a 1/7 report of the Law Commission of India, written by Justice D.A. Desai, called Judicial Officers Training, Justice D.A. Desai did not use these words but recognized it. And he said, overnight, this judicial system has to transition from being an extension of the law and order machinery, his words, to becoming a sentinel on the qui vive, a guardian on the alert of fundamental rights. And he said, this is a massive, overnight, this is a massive task. He asked for judicial academies to be set up. And it is for that reason, actually, the judicial academies were set up. But today, many academies are focusing only on statutory interpretation. And in the statutory space, how to find the rules and apply it. But they are not paying enough attention to the real purpose for which these academies were set up, which is not to train them in craft and knowledge, but to help them to understand how to deal with a completely new challenge. How to protect freedom, equality, dignity, fraternity, and democracy as constitutional rights. So I feel that legal education must devote huge amounts of time to these ideas. We don't know. You talk to members of the bar, you ask them what is justice, they don't know. I've given you a definition. It's a standard of human conduct, right? For our purposes. Not as a universal definition, but for legal analysis purposes. I've told you that as a general proposition, it's a word which is an empty word. So forget about defining it. Different people can put different content into it. That it is a standard of human conduct is the content that I am suggesting for it in law. But you ask these people what does liberty mean? What does freedom mean? What are the nine restrictions you can put in under 19.2 on 19.1? And each of those needs to be properly educated. In most of the country, lawyers and judges are interpreting sedition as Deshdroh. They've never heard of Kedarnath versus State of Bihar. And they are just applying the law as if the constitution doesn't exist. So, Safi, I think the problem you're identifying arises from the fact that we are not doing our job in the classroom anywhere in this country. That we are not giving importance to this new challenge in which the judiciary and the bar has no experience. How to defend Stan Swami's rights, whether it's right or wrong. How to defend liberty, equality, dignity, fraternity. We don't know how to do it. We have no jurisprudence on it. The jurisprudence we have is very little. So we are not building the jurisprudence on it, not just making speeches on it, but really studying it, analyzing it, technically analyzing it, and giving. I think lawyers and judges can only apply rules. They have to draw lines. When should bail be given? When should bail not be given? When should there be remand? When should there not be remand? We are not teaching those lines based on the new constitutional philosophy of liberty and fraternity and dignity and equality. So I think the classroom is failing.
So another fact that I found from your speech, we need institution for not only lawyers, but for prosecutors, lawyers, and law teachers. I think we didn't have any institution for law teachers or even for the prosecutors, because I think we have almost 11 prosecutors are there in this age, but without any legal institution in order to provide continuing legal education for the youth. I think even I think even in our Kerala State Bar Council, we don't have any for lawyers.
Yeah, Safi, let us begin with teaching the law students, trying to improve the content of the classroom all across the country in terms of what our law students are getting. Then they will become prosecutors, so we cannot neglect them and start teaching the prosecutors. Let us first focus on producing in the next 3 years or 5 years much better law graduates. And then they will become prosecutors, they will become judges, and we don't have to worry. There will be gradual change. That is something we can do. And I think we should focus on the quality of what we teach, and also give much more priority to teaching this aspect of the Constitution. The democratic part of the Constitution, the democratic dimension of the Constitution, that is completely new. We as academics also, there are wonderful academics who've written wonderful things about it in all across the country. We need to bring all that together, and we need to concentrate on teaching constitutional democracy in our classrooms.
Thank you very much.
Thank you.
Excuse me, sir. I have one question.
Yes.
Sir, I observed the nature of judicial process written by Benjamin Cardoso.
Yes.
So, in that, I don't remember which para. In that, Cardoso explained about the jurist must be like a person going for selecting dress in a textile. Suppose I will explain that the jurist who is a person who always carrying a thread, that thread he have to select which dress is suits for that thread. So hello, am I audible, sir? Hello?
Sorry. You can hear.
Yeah. So
can hear you.
the jurist must be having a thread. That is problem. So when we going to textile, that justice dress is called justice. So jurist must be select some justice from the textile. I don't remember which para in the nature of judicial process. That book he explained that it's like a justice is coming through by that same that reason might be apt suits for that process of selection. I don't know whether Kumaran sir can explain that.
No, I'm familiar with that book, and in fact I just wrote a long article about it, because this is the 100th anniversary of the publication of the nature of judicial process.
Yeah.
It was published in 1921.
Yeah.
And so it is 2021. It was delivered as a Stoss lecture, and then it was published in 1921. I don't recall this particular discussion, but in any case, for us in our country, the challenge, see, he had published it, delivered the lecture and published it in 1921. By then, they had had a civil war in 1861 to 1865. Before that civil war, see, we must understand that these Western countries are standing on a foundation of centuries, 13th century scholasticism, when religion was rigorously re-examined by the church itself. What kind of religious beliefs should be rejected, what should be kept because of the rise of science. After that, Protestantism in the 16th century with Martin Luther in Germany, and then the Reformation, and so then the Enlightenment. So they had huge history of change. And then after that, these nation states developed. In America, they created a republic. They created a constitution. And in the 8th decade of that constitution, from 1861 to 1865, they had a civil war between a conservative South and a progressive North. A civil war in which 2% of the people died. We are now in the 8th decade of our constitution. it was in this period that America had a civil war. Because 8 decades of a constitution in a conservative society had awakened ideas of freedom and equality. Not awakened in the political system. It's always there for every human being. Had created space in the political system for these ideas of equality and change. So there was an explosive reaction to that. I see, and the big backlash. And we are coming to those stages. So on top of all that, then they had a movement of realism to oppose the classical jurisprudence, and people like Roscoe Pound and Cardoso, and were all part of that realist jurisprudence. Now, what I'm saying is, he may speak about those things. Right now, for us, according to me, the priority is to push back against the obedience-based, faith-based, backward-looking society where the future is behind us, 5,000 years behind us. We are trying to move backwards in reverse gear, right? And we are afraid of individual liberty. We are afraid of equality. We are afraid that if these ordinary uneducated people come to power, then this country will be ruined. But we have to embrace ideas of freedom and equality which are new to us. We don't understand those ideas. We have to understand reasoning. We have to understand evidence-based thinking. We have to push back against and scientific thinking, push back against superstition. And these are the challenges that we have in our society. And so this is the heart of justice. It's only when we internalize these values will there be justice. Justice is not simply following the Civil Procedure Code or the Constitution. Justice is a society that practices these values of reasoning and logic and freedom and liberty and equality. That is justice. Then we say we have realized justice when that happens. So now we have to start the process of understanding these concepts. Not that we are strangers to them. See, this society knows Satya, right? It is it has its own number of traditions, not just one tradition. Again, we are trying to homogenize this country and destroy its plural nature. But we have a lot of no human being is without a history and without tradition. Every human being has knowledge, tradition, history. But every human being faces the challenge of adapting those knowledges to current challenges, understanding the situation and moving forward, not backward. So that's where we have to, I think legal education cannot be confined to simply teaching rules, learning rules by heart from statutes or precedents, and then reproducing them in an answer paper, and then using that to get relief for clients. Who is going to take care of this, what Justice D.A. Desai called this transition of the entire role of the legal system from being a part of the law and order machinery to being a guarantor of freedom and liberty and equality. So let us focus on understanding these issues, whether, what is equality, what is freedom, particularly, what is democracy, why power should be held in the hands of the poorest people, not an elite, why it is important to have all groups, regardless of their capability or so-called capability or no capability, have voice and equal share in power. These are the ideas that we have to learn, understand, propagate, and that is justice. That is constitutional justice.
I'm thinking, it's like a utopian idea, because justice, it's not at all getting that in that proper public, because justice is equal to money. Because when I reading Supreme Court judgments and daily Hindu papers like news related to courts, have different high courts, I don't think so. Where is the justice? Justice on the part of the hands of the politics or in the hands of the prime minister? I just scared about daily judgments when I reading about. I don't think so. Yeah.
These are the kinds of debates we should have. What is justice? How do we get it? So I am giving you one approach, that justice is a standard of human conduct, and its core, for our purposes in India, justice means people having freedom, equality, dignity, and fraternity. Right? And it starts with my own conduct, that I should respect freedom of others and the equality of others, the dignity of others. And I should ensure that within my power that everybody does that. And I should also ensure that we make decisions that affect each other based on facts and evidence and truth, and not based on superstition. That we should have no prejudices. We should have, we should not act without rationality and reasoning. These are all daily practices. If we in our classrooms can habituate our students to these practices, that they are treated with equality, that they should speak, but they should speak with rigor. They should speak with knowledge. They should speak, not, or based on logically. So we have to explain to them what is logic, what is, how do you think in a way that is effective to convey your points of view. So this is where we have to build a democratic culture. Democracy, simply as I said, means Kratos, power is in the hands of the most common people. So let's start with understanding that this requires all common people to be given freedom and equality, not given, but they recognize their freedom and equality and dignity and treat them as such. That is constitutional justice. Justice is not a prime minister doing the right thing or the wrong thing. Even if the prime minister does all the right things, even if a father or mother does all the right things, that's still not justice under our constitution. Justice is my having power, my having, freedom, my having liberty, my having voice. That is justice. Not somebody doing the right thing for me.
Thank you, sir. Thank you.
That's what I meant by saying I wanted us to democratize the idea of justice.
Good evening, sir.
We have
Good evening,
in
sir.
the chat box.
Yes.
Okay, sir, I just had one question, sir.
Yes.
Thank you, sir. So, with regard to, I had a question with regard to the powers of Supreme Court judges and their conduct. And my question is especially on the light of Ranjan Gogoi's issue.
Yes.
When an allegation of rape trailed against him, he constituted a bench for himself and sit for. Okay. So I believe there should be a check mechanism to control this powers of Supreme Court judges. What you suggest? How can we use our constitution to protect ourselves against this kind of usage? And I also think that should reverse all the judgments he made that time, especially Ayodhya and Rafale, to protect our constitutional morality. What do you take on that? Thanks for the talks. It was very nice.
Thank you very much. Very, very good question. I think judicial accountability is very weak in our country. We don't have adequate institutional mechanisms for that. And that is part of what I said. Democracy is new to us. Freedom is new to us. Equality is new to us. Everyone having equal dignity is new to us. Fraternity is new to us. And accountability is new to us. Accountability of the powerful to common people is entirely new to us. So that's why I think in legal education, these kind of new ideas, democratic ideas, constitutional democracy must occupy 70-80% of legal education. Otherwise, this country is not going to change. And then these educated students will go out and not behave in the manner that this judge has behaved. And they will build institutions of accountability. I agree with you that we need to build institutions of judicial accountability. We don't have them. But the solution will come from people like you, young people, students, like a bunch of judges reversed ADM Jabalpur. You want to reverse this, you become Chief Justice of India, you constitute a bench and you reverse it. And then we will all applaud for you. And I'm sure that will happen. So, so all these revolutions begin in our classrooms, in our discussions. So we have enormous opportunity to solve these problems through our own classroom interventions. Yes, sir.
So, sir, we have three more questions in the chat box.
Yes.
Can I
Yes,
put it? Can I read it out?
yes, sir. Yes, sir.
So, would you please switch off your mic when I speak?
Yes, sir. Yes, sir. Yes, sir.
There is an echo, that's why. So, Shaji Malat asked the question, what is the alternative when justice becomes just ice? What is the alternative when justice becomes just ice, or it is not operational or superficial?
The my response to that is we have deeply embedded in our head is the idea that justice is a right decision made by some superior authority. That's a very feudal idea. So when we say justice it becomes ice, what we mean is that some superior authority is not actually making the right decision. So that's justice or injustice. But when that is done, that's why judges come home and say, I have done justice. Right? Maybe you have, maybe you have not. But so we have to move away from this feudal idea, and we have to democratize the idea of justice. And we have to say that actually justice prevails only when people behave to each other. Now, as Prithviraj Chauhan says, when people treat each other in accordance with constitutional norms of conduct, that is justice. So yes, the judge has to treat people like that. I have to treat people like that. Everybody in between has to treat people like that. That is justice. So that cannot become ice, sir. Where and when that becomes the culture of the people, then I think what we will also find is that when the other part, equality, comes in, and there is everyone gets their share of power, the decision making also gets fragmented and democratized. Then you won't have to wait for one big Chief Justice of India to make one big decision to affect everyone. So in fact, that should not happen. That now there is extraordinary concentration of power, which is actually going against our constitutional idea of justice, and at the heart of which is democracy. So if we train our students to understand that justice is actually nothing more than under the Indian Constitution, nothing more than the prevalence of democracy, then they will understand that, and they will themselves be agents of fragmenting power, decentralizing power. So that is my response to that. We have to reconsider our idea of justice.
So the last.
Yes, sir. I'm not able to hear you, sir.
You're muted.
She agrees that the religion is flawed, but where does righteousness stand then? In her understanding, religion essentially derives from all the justice derives from all religions in different forms, and even Dr. Ambedkar has made a mention to righteousness. Second question.
Yes.
And coming to conscience, studies have revealed that there are people who don't have one, like psychopaths or sociopaths, etc., and might be in positions of power, and they would not care for law and may even try to manipulate it. So how can law approach to rectify this? These are the two questions.
They are very, very good questions, and things that it's something that should be debated. But would you actually say that righteousness comes from organized religion? I mean, there's an assumption there that religion is flawed, but where does righteousness stand then? So I think the assumption seems to be that somehow righteousness comes from organized religion. I think that is a proposition that needs to be carefully considered based on evidence. Maybe there is some righteousness that comes from organized religion, but there is also a lot of bad stuff that comes from organized religion. And so righteousness and religion should go together, but that's a claim, but it doesn't. And now the second question is, what do we mean by righteousness? So justice is actually a standard of right conduct. So being justice being righteous. So righteousness means respecting the freedom of others, exercising my own freedom in an independent manner, respecting the equality of others, valuing the dignity of others, and seeing others as just human beings, not believing in these superstitions such as caste and race and gender. Gender does not mean biological difference, but the social construction of difference between male and female. That's what we mean by gender. That's entirely false. It is constructed only for the purposes of exploitation. Similarly, caste is just a superstition. It's entirely false. So I think righteousness is or comes from this idea of justice that is in our constitution. And ultimately these ideas will result in a compassionate society, because we will respect others' freedom, others' equality, others' dignity, and ensure that they have the opportunity to pursue what they choose to pursue. So that is the concept of righteousness that is in the constitutional vision of justice, or the constitutional idea of justice. There could be other standards of righteousness, but I think this is what Dr. Ambedkar referred to in the Constituent Assembly as constitutional morality, which is basically a sense of constitutional righteousness. And justice, coming from the word jus, which means the right value, justice is a standard of right conduct, and therefore it is also a standard of righteousness. And I don't think, frankly, my spiritual needs are different, but for social needs, I need to go further than this framework that is in the Constitution of treating everyone, respecting their freedom, equality, and dignity, and with an attitude of fraternity. And conscience, yes, conscience is simply the ability to distinguish between what is right and what is wrong. And you're saying there are people who don't have one, psychopaths, sociopaths. Yes, they are. Some of them are the product of extreme violence and so on. They're when you say paths, they are pathological, and they require treatment, and they require help. And society must be arranged to identify such people and provide them the help that they need. But we are not talking of, there is a saying in law that bad cases don't make good law. So we can't construct a worldview based on psychopaths and sociopaths. We have to construct a worldview based on how normal people work. Then we have to have an arrangement to take care of psychopaths and sociopaths that is compassionate and understanding, and will help hopefully to offer therapeutic options to them. Yes, a lot of these concerns are true, but I think what we are talking about here is something very, very fundamental and basic, that we understand the Constitution as an attempt, as an argument about how we must treat each other in a different way. And that's what the Supreme Court has said in Prithviraj Chauhan. The Constitution is an argument that we have to change the way we treat each other, that we have to treat each other on the basis of freedom and equality and dignity and fraternity. So if we just focus on that, that's not going to solve all the problems of the world. We'll still have problems on righteousness and manipulation and all that. We'll deal with all that. But let's focus on the way we treat each other. I think everyone who comes to this country realizes that this is one country in the world where people treat each other wrongly. We have a lot of wonderful things about our country, but we don't treat each other well. We don't see the humanity in each other. And Dr. Ambedkar once said, our struggle is not for power. Our struggle is not for wealth. He said, our struggle is to reclaim our humanity. And it's very sad that 90% of the people of this country have to say that 10% are not able to see their humanity. And that says a lot about the deep, deep damage, psychological and intellectual, that has been done to the ruling 10%, that they're not able to see the ordinary humanity in fellow human beings. So the Constitution is an argument that we have to fix that, and we have to see each other as fellow human beings, members of one species, treat each other with equality and dignity and respect and love, and then sit down together, talk to each other, ensure that everyone has an equal share of power, think rationally, think in a secular manner, basically not based on personal predilections, but based on proved facts and evidence and logic. And then we will create a society with a rational, reasonable public space, a peaceful space that will never have to see the kind of civil war and the Holocaust that we saw in 1947. Thank you, sir.
Okay, sir. There are.
I'm not able to hear, sir.
The first question is related to what you have referred to as constitutional righteousness. The question is, should the growing idea of constitutional morality be taken as an attempt to ensure constitutional justice in India? Constitutional morality can be equated with constitutional justice in India. That is the first question. And the second,
sir, I can see both questions here, sir. I will just answer it. I can see it. Sir.
Okay,
I can see
thank you,
both
sir.
Sandra Suresh and Subir Bhatnagar. So thank you, sir. And I will very quickly respond. The first question says most judgments are based on evidence and facts, but in such situations, justice often gets denied. So in such situations, how can we describe justice? So we have to distinguish two things. One is, how do we measure and evaluate the rightness or wrongness of a judicial decision, right? We can't say that a judicial decision is justice. Now we know, and I share this this view when I talk to in the Judicial Academy also, that we don't know how to measure the quality of a judicial decision. Now you are saying justice gets denied, which means you have your own idea of justice. Why should others accept that? You should have your own idea of justice. I strongly encourage that. But we also need to have a shared idea of justice. So how do we know whether a judicial decision is right or wrong? Now we talk of merit-based society, and reservations are destroying merit. But on something simple like, what is the quality of a judge and a judgment professionally? What is the professional quality of a judge? We don't know. We don't know. In other countries, there are indicators to measure the quality of courts and measure the quality of performance of teachers, judges, doctors. We don't have any of that. So I have proposed, for example, that the quality of a judgment should be based on what I call a rights protection index. Rights protection index. Because we have these values of equality, dignity, liberty, fraternity, as I said. And in order to realize that, the Constitution and the statutes create rights. As Hofeld has said, described rights are a set of claims and privileges with power and immunity to protect those claims and privileges. Right? Now, if the rights are claims and privileges flowing in order to protect freedom, equality, dignity, fraternity, then those rights have to be protected. And the protection of those rights is justice. Now, those rights have to be protected based on the facts. Now, the rights are protected through creating law. Law is a set of hypothetical facts, and when a actual fact pattern occurs that is inconsistent with the prohibited fact pattern in law, then you have a remedy. So there is a logical framework to connect the idea of justice as a standard of human conduct, a set of claims and privileges to protect those standards of human conduct, which are rights, and a set of procedures and remedies through which those rights can be claimed if they are violated, and that is justice. That's a framework of justice, not an arbitrary personal sense of what is, this is just, that is not just, and that becomes like, panchayat justice, which is fine. Panchayat justice is fine, but the difference between a doctor and a Vaidyan is that the doctor has a particular method of thinking. The difference between a panchayat judging process and a legal judging process is that we have a separate way of thinking, method of thinking called legal reasoning. And that legal reasoning has to be taught in great detail in law colleges. We are not doing that. And that has to become habituated to us. We must think like lawyers, do legal reasoning. And then the idea of justice will clear up in our mind, and we'll understand that when legal reasoning is followed and rights are protected, that is what justice is. Now, actually, Professor Kumaran had referred to it, and therefore I remembered it. In Minerva, in his dissenting judgment in Minerva Mills, Justice Bhagwati has a very, very crisp description of what the role of a court is, and he says the court is concerned only with the adjudication of legal rights and liabilities. That's all a court does. And when those legal rights and liabilities are adjudicated in order to promote a standard of human conduct which is set out by the Constitution, that is justice. But a court is not a panchayat that will take care of a plenary idea of justice. No. As Justice Bhagwati said, a court is concerned only with adjudication of legal rights and liabilities. That discipline is being lost. And we are converting courts into general places of grievance redressal. Anyone has a grievance, go to court, file a case, and ask for relief. And so this whole discipline is being lost. And the idea of justice then is becoming very arbitrary and very subjective. So, yeah, so in such situations, if it does not involve adjudication of rights and liabilities, then other remedies have to be looked for, social remedies through mediation, arbitration, through negotiation, through various other mechanisms have to be sought. And Subir has asked, should the growing idea of constitutional morality be taken as an attempt to ensure constitutional justice in India? No, I think it could, but it's also dangerous, because constitutional morality cannot now become another indisciplined way, a non-rigorous way of thinking about very clear ideas that constitute justice, very precise ideas of liberty, equality, dignity, fraternity, and part 3 of the Constitution and part 4 of the Constitution. These are the legal ideas of justice. Please remember that courts and all of us are concerned only with legal ideas of justice. We are not here to do social justice, political justice. When we do legal justice, that will contribute to social justice. But ultimately, in a democracy, each of us as citizens are responsible to ensure justice and to protect justice. And the role of the court should be very clear. So, yeah, constitutional morality should be developed in a very clear and precise manner, not to be confused with social morality, which is usually the way the elites want you to behave. And that is usually misogynistic, it is casteist, it is communal, it is very dangerous. And so constitutional justice and constitutional morality should be used to counter these kind of ideas and to advance the constitutional values which I talked about. Okay? Thank you very much.
Kumaran sir, unmute ചെയ്യണം.
Professor Krishnakumar, we will conclude.
Okay, sir. Okay. Let us conclude.
Please propose the vote of thanks.
Okay, sir. A very warm good evening, one and all part present here. Honorable Chief Guest of our today's function, Dr. Mohan Gopal sir, respected Principal C.V. Kumaran sir, and all other participants. It is such an honor for me to get the opportunity to thank all the dignitaries. I extend my gratitude to our honorable chief guest, Mohan Gopal sir, to take out time from his busy schedule to grace the event. Thank you, sir, for inspiring and encouraging us with your thought-provoking words. A special thanks to C.V. Kumaran sir, principal of our college, for providing immense support to make this program successful. I extend my gratitude to Mr. Vidit, who has introduced our chief guest and delivered the welcome address, and also faculty members of Government Law College, Calicut, the college union, students of our college and other colleges, judicial officers, lawyers, and other members of our legal fraternity who have participated in this program, even amidst this pandemic. Once again, on behalf of the staff, faculty, and students of Government Law College, Calicut, I express my gratitude to all the esteemed dignitaries of this inaugural function of the lecture series of our law college for their presence and contribution to make this program a great success. Thank you on my part. Thank you.
Thank you, sir. Professor
Thank you.
Kumaran. I just wanted to say my own thank you to you, sir, and to all the other faculty members and students and all those who listen and all those who raised very good questions. It's been a great honor and pleasure and privilege. Once again, congratulations on the Golden Jubilee, and I wish you the very best for the celebrations of the Golden Jubilee. Thank you so much. Thank you very much.
Thank you. Thank you so much, Mohan Gopal.
Thank you, sir. Thank you, Vidya. Thank you so much.